state wants Mr. Chambers to die in prison for defending himself. And a few minutes ago, one of Mr. Hood's best friends came before this court, used a racial epithet, said, "That's just how we talk, it's just a word." And I wouldn't expect, quite frankly, that either myself or Ms. Davis would really know what that word means, especially to an African-American person, especially to an African-American person of Mr. Chambers' age. And I quite frankly needed a friend of mine who's African-American to educate me on that. This friend of mine who's African-American told me about a conversation he had with his grandfather. And his grandfather told him what that word means to a man of his age, to a man who's probably experienced some of the same things as Mr. Chambers. And what that word means, whether it's with an A or whether it's with an ER, if it's being said by a white person, and I would suspect especially if it's being said by a white person from the South with a Southern accent, because that carries with it loaded connotations and loaded meanings. What it means is that your life has no value. You can be hung from a tree. You can be dragged out of your house and burned. You can be buried alive, and you will have no recourse. No one cares, because your life has no value. And so, in any meaningful way, it should be clear, it should be undisputed that those words were used by Mr. Hood and Mr. Voss, directed at Mr. Chambers that night. So, why wouldn't he panic? Why wouldn't he be horrified at what these people were likely to do to him? And especially as the prosecutor, not surprisingly, omitted when one of them, Mr. Chambers thought, flashed a knife, and of course there was an open knife found in the back of the truck. Why wouldn't Mr. Chambers panic? Why wouldn't he have a hard time getting his car started? Lord help any of us who is faced with a threat to their life and doesn't behave exactly the way Miss Nave thinks they should. I would suspect neither she nor I, if we were faced with a threat to our life, would behave in any sort of optimal way. The fact of the matter is that the facts of this case, the law, and any sense of justice allows this court to give Mr. Chambers the exceptional sentence downward that the defense suggested. The state, in their argument, again, as at least for my position, as they have been wont to do in especially the latter parts of this trial, played fast and loose with what the evidence actually was and with what the truth actually is, which is that all the evidence at trial, both adduced before the jury and adduced to your honor that the jury didn't get to hear, is that Mr. Chambers is a kind, gentle, peaceful person, drunk or sober. And I know, and I'm certainly not seeking to relitigate the issue of what Sarah Chambers was allowed to tell the jury about Mr. Chambers' behavior when he was drunk, but she's known him for 23 years. She's seen him drunk. And she, through counsel, proffered to the court that he gets silly and he gets tired when he gets drunk. It wasn't that he became drunk and he somehow then was likely to become enraged. That's simply not the truth. That's a fallacy maybe the state would like to believe. Their own witness, Leslie Johnston, testified at trial that Mr. Chambers was always relaxed. He was always congenial. She wrote a letter that the court has before it. She said that night he was even more relaxed than usual. That night, Mr. Chambers had everything he could possibly want in the world, and it had taken a lifetime to achieve it. His struggles, those which that were not his fault and those of which that were well documented through his own testimony, through the testimony of Dr. Cunningham. But he had love, friends, family, home, work, anything anybody could ever want. He had a gun that he was not allowed to have, but he never pulled that gun in anger in the 2 decades that he had it. He never hold that gun in some sort of misapprehension of threat that wasn't there. That never happened. Mr. Chambers told the court what happened. He told the court exactly what he was feeling, what he was thinking, the things he remembered, the things he didn't, and he was consistent throughout. That in and of itself is a factual basis for this court to grant the exceptional sentence downward. Mr. Voss also helps support the basis for an exceptional sentence downward, although I would be surprised if this court in its 16 years have heard a less credible witness than Mr. Voss. But although in general he lacked credibility, he was also very clear that Mr. Chambers responded in a way that showed he was acting in self-defense, that Mr. Chambers didn't make any threats towards that they didn't even know he had a gun. The state repeatedly in their argument said that Mr. Chambers followed Mr. Hood, Mr. Chambers followed Mr. Hood. Well, not even Mr. Voss said that. What Mr. Voss said is he actually didn't really, he saw Mr. Hood come from behind the van. According to him, Mr. Chambers was a few steps behind, but he didn't even acknowledge it as following him. It was only once Mr. Hood had turned towards the truck. Mr. Chambers, of course, said what actually happened, which is that he was trying to get into a better lit area, and that it was Mr. Hood who was following him. And he had no idea he was actually moving towards Mr. Hood's truck. Mr. Voss is unequivocal that there was no indication that Mr. Chambers had a gun, no indication of threat, until Michael Travis Hood picked up that shovel and brandished it like a baseball bat. And Dr. Lubin, the state's witness, the medical examiner in this case, was also unequivocal that that shovel was capable of killing a person. It was capable of causing, at the very least, grievous bodily injury. There was no doubt about that. Dr. Lubin also supported that Mr. Hood was facing Mr. Chambers or the possibility that Mr. Hood was facing Mr. Chambers at the time he was shot. Mr. Voss described Mr. Chambers as acting in a way a person does when they're faced with a mortal threat. He gave that very specific description of Mr. Chambers jumping back like he had seen a 7-foot-long rattlesnake. The shots that the state belabors is one shot after the other, after the other, after the other. Again, that's actually a gross mischaracterization of what the evidence actually was from their own witness. Mr. Voss said that there were, from the time Mr. Chambers jumped back to the time the 3 shots were completed, was 1 to 3 seconds. So it wasn't as though there was some sort of calmness or deliberation that the state's trying to suggest. All of these things, the jumping back, the shots close in time, the presence of the deadly weapon in Mr. Hood's hands, Mr. Chambers' credible testimony, his peacefulness, his lack of aggression, Mr. Voss's lack of credibility, the fact that Mr. Hood had been kicked out of a bar a week prior for acting aggressively and using racial epithets, that whether that night they were particularly directed toward African Americans, were no doubt the sort of racial epithets that target African Americans, all of those things provide the court with the basis of an exceptional sentence downward. As the court certainly knows, we believe those facts actually support acquittal in this case, but at the very least, they support this exceptional sentence down. There's also undoubtedly the legal basis for an exceptional sentence down. There is the RCW 9.94A 535(1)A that certainly gives the court a basis. The state provides no contrary authority and seeks to distinguish Pascal and Brunel. But the fact of the matter is that the RCW in those cases stand for the proposition that when the facts support it, as they do here, that is the basis for an exceptional sentence. There's no limitation on Pascal, only the DV cases. There's no question that Mr. Chambers was in a fight for his life that night.
How could the court find an exceptional sentence appropriate under RCW 994853551A that the victim was the initiator, willing participant, aggressor, or provoker when the jury rejected the self-defense theory?
We don't know, quite frankly, what the jury did. It appeared, I think, anybody looking at the verdict rationally as some sort of a compromise. But what the RCW says is that if the court finds substantial and compelling reasons demonstrated by preponderance, and then lists some enumerated factors, and one of those is obviously that to a significant degree the victim was an initiator and aggressor, the court is entitled to impose that sentence. This isn't as though it's one of the statutory aggravators that we would have to prove to the jury, or that the state would have to prove to the jury in order for the court to impose. The state certainly provided no authority that when a guilty verdict occurs, because these exceptional sentences only occur when there's some sort of a guilty finding. There's absolutely no authority for the proposition that when there's a guilty verdict, then the exceptional sentence is not warranted. In fact, as I said, all the legal authority points to the fact that this is precisely what the court is able to do. All of the facts point to the fact that Mr. Chambers' testimony taken, even on its own, is sufficient to demonstrate to a preponderance that Mr. Hood and Mr. Voss were the aggressors and provokers. And even putting aside Mr. Chambers' testimony, Mr. Voss's testimony on its own is sufficient to demonstrate that. Because what Mr. Voss says is, Mr. Chambers essentially didn't do anything until Mr. Hood picked up that shovel and held it like a baseball bat. And as the court will recall, when I was asking him about that baseball batter stance, what Mr. Voss said was, I take it as the person was going to swing, wouldn't you? And I said to him, yeah, absolutely. That's the very essence of the factual basis for an exceptional sentence downward. So I think either on the basis of Mr. Chambers' testimony or, quite frankly, on the basis of Mr. Voss's testimony, the defense has demonstrated that there is the legal basis and the factual basis for an exceptional sentence down. Contrary to what the state is suggesting about the defense presentation about Mr. Chambers' life, I'm not asking the court to give him an exceptional sentence downward based on the circumstances of his life, based on the fact that, as the court articulated, you've never seen so many letters of support on behalf of an individual. I'm well aware that the case law doesn't support giving Mr. Chambers an exceptional sentence because he's a good and peaceful person. He is a good and peaceful person, but I understand that's not what the law allows an exceptional sentence for. It is still important that the court knows that about him in terms of fashioning the sentence in this case. And, you know, the fact is that time after time, the court gets letters about Mr. Chambers from people, not people who've known him for a couple years or months, but people who have known him for decades. Every single person, including one of the state's own witnesses, Leslie Johnson, says the same thing about him. He's calm, he's peaceful, drunk or sober, angry or happy. He is not somebody who does this unless they need to protect themselves. And I think it's particularly important when the court looks at the letter from Leslie Johnston. She talked about a specific incident a couple years before January 21st, 2012, where she was being threatened, and where Mr. Chambers came to her aid. And he didn't come to her aid by trying to be aggressive against the person who threatened her. He didn't come to her aid by saying, you know, I'll walk you to your car and I'll flash my gun at this guy and get him to leave you alone. What he said to her is, I'll help you work with the police and with the courts to see if we can get you protected because you're being threatened. It means something, and the court should certainly take note of the fact that there absolutely no evidence to suggest that Mr. Chambers ever would have done this, but for that he needed to defend himself. That's what he said. What Mr. Voss said, despite himself, quite frankly, supports that, and there's been no meaningful evidence to the contrary. Now, the state's recommending the high end of the standard range. The court sat through this trial. I'm quite frankly appalled that based on the facts of this case, they think that is an appropriate recommendation. The state suggested Mr. Chambers should have run away from these men who were 20 or 30 years his junior, despite the fact that there would have been no chance that he could have run away from it. That despite the fact of his age and his medical problems and his physical problems. The state argues that there are all these options available to Mr. Chambers, even though this incident happened within seconds. Even though Mr. Chambers explained that the reason he didn't go and try to force his way back into the feedback is that was the last place he saw the person who he believed had a knife, and he was trying to avoid a confrontation. That yes, he could have pulled out his gun, I suppose. He could have fired warning shots in the air. He could have, pulled out his gun and charged back into the feedback, brandishing his gun, yelling threats. But had he done that, the state would have been here saying he was being reckless by pulling out his gun. He was being reckless by shooting his gun in the air. He was being reckless by any other action. The state, again, tries to emphasize that Mr. Hood was shot 3 times. There's no question that he was, but there's also no question that those happened within seconds. And that certainly doesn't demonstrate any recklessness. And then the state tries to argue that Mr. Chambers was drunk, and so he should be punished for that. Mr. Chambers was drunk in a place that he'd been going for over a decade. He chose specifically because he felt safe there. It was, quite frankly, tantamount to him being drunk in his own living room. And if, the state believes that you act recklessly in defending yourself when you have no idea that a threat's going to occur, when you have no idea it's going to occur because you're in a place that you believe is safe, I just think that is a grave miscasting of what the facts are in this case, and quite frankly, what the truth of the matter was. If Mr. Chambers had any idea he was in a place that was unsafe, if he had any idea he was going to face the threat from Mr. Hood and Mr. Voss that he did, he would have steered well clear of those men, because that's what he has done throughout his life, and the court heard that from Mr. Chambers. If nothing else, this case has demonstrated to me the limited value of my talking, because I frankly can't imagine a world that Mr. Chambers should have been convicted. And when I talk to people about this case, they're constantly shocked by how he was convicted. I have pretty clearly demonstrated that there's not very much I can do for Mr. Chambers, but the law and the facts allow this court to do a measure of what's right, which is to give him the 5 years. Mrs. Chambers, who testified at trial, would ask to address the court as well.
All right, very good. Come forward, Mrs. Chambers. Good afternoon.
Good afternoon, Your Honor. Your Honor, I have been married to Lovett Chambers for over 22 years. He's always been a kind and gentle husband. He's well-known in his community. He has many friends in his community and is well respected. I've seen him sober and I've seen him drunk. I've seen him happy and I've seen him sad. And consistently, he is an even-tempered man who thinks of other people as much as he, cares for himself. He's not a man who would be aggressive toward a stranger. He would only defend himself if he felt that it was his life that was threatened. Thank you.
All right, very good, thank you. And Mr. Goldsmith, did you say there was someone else who wanted to speak on behalf of Mr. Chambers?
I believe it was just Mrs. Chambers.
I see. All right. And Mr. Chambers, is there anything that you would like to say? I don't think this is an appropriate case for a sentence below the standard range. As I said, I'm impressed with all the letters of support that I've received from Mr. Chambers. He has had 20 years of law-abiding behavior. I understand from the testimony about his difficult childhood and the many years he spent in high-security prisons in California, one place, San Quentin and Folsom, and I'm sure that those were horrible experiences. But I don't find, based on the Frieda case, that the court can consider a history of law-abiding behavior as a basis for an exceptional sentence below what the legislature has determined to be appropriate, that is the standard range. The other possible basis for imposing a sentence below the standard range is what's called imperfect self-defense. That to a significant degree, the victim was the initiator, willing participant, aggressor, or provoker. There was a real dispute about that at trial. Mr. Voss testified that he and Mr. Hood never called Mr. Chambers names, never tried to get into his car, that at Mr. Hood's truck, that Mr. Hood picked up the shovel and held it defensively, and then Mr. Chambers shot him. Mr. Chambers' version is very different. He testified that Mr. Hood and Mr. Voss called him vile, racist names, tried to break into his car. Then at the truck, Mr. Hood threatened to knock his head off with the shovel that she was holding up in a battered stance, and Mr. Hood then shot him. As is clear, the jury didn't believe the self-defense theory, and they found him not guilty, apparently, or couldn't agree on second-degree murder, and found him guilty of manslaughter, apparently finding that he recklessly caused the death of Mr. Hood. What wasn't disputed, though, was that Mr. Chambers had a .20 blood alcohol content many hours after the shooting, so he was obviously extremely intoxicated. And it may be that he doesn't remember a lot of what happened, and that would not be unusual. What's not disputed is that in this state of intoxication, he retrieved his loaded handgun from his car. And then, whether he was following Mr. Hood and Mr. Voss, or for whatever other reason, he went from his car and walked about a block up to Mr. Hood's truck. And that's where the incident occurred. Mr. Hood picking up the shovel, Mr. Chambers shooting him 3 times. Really was no sensible explanation about why Mr. Chambers would then follow Mr. Hood and Mr. Voss up to the truck. That was the big gap. Why did he do that? So in looking at the evidence in this case and making a decision under the case law and the statute, is this behavior significantly less egregious than what one would find in an average case of manslaughter, of recklessly causing the death of another person? And under these circumstances, I can't find that that's the case. So for those reasons, I'm not going to impose a sentence below the standard range that the legislature has set, which is 78 to 102 months. I do, however, think that this is an appropriate case for the bottom of the standard range, and largely for all those same reasons. There was a very sharp division in what happened, in the evidence, whether Mr. Hood and Mr. Voss engaged in racial slurs, whether they used the N-word, whether Mr. Chambers overheard them, or whether they actually were following him and yelling racial slurs at him. It's also clear that Mr. Chambers had a very high BAC, and that may be one of the reasons why the jury found him not guilty or could not agree on the second-degree murder charge and found him guilty of manslaughter. Based on all the evidence in this case that the court has heard and all the evidence presented to the court in favor of Mr. Chambers, and also evidence in support of Mr. Hood and what his nature was, the court thinks it's appropriate to impose the bottom of the standard range, and I'll do that. That's 78 months. The court has no discretion and is required to impose the 60 months mandatory firearm sentence enhancement. And so that is a total of 138 months. I'll also impose a order that there be no contact with Jonathan Voss, members of Mr. Hood's family, including Mrs. Brenda Hood. I'll impose the mandatory $500 victim penalty assessment and $100 DNA fee. And I don't know if the state's requesting restitution or
Your Honor, there may be, could
particular
we
amount.
set a hearing if there is restitution?
Right. And I will impose community custody as required by law of 36 months.
Your Honor, I'm assuming you're waiving other costs.
I am waiving not all of the discretionary other financial obligations. And I believe that concludes the conditions.
Your Honor, we're asking that the court set an appeal bond of $50,000 in this case. That's an extraordinary amount of money for the Chambers family, but it is an amount of money they can pay for. If Mr. Chambers does not pose a risk of danger to the community, nor a risk of flight, in spite of the sentence, just because if he fled, that would leave Mr. Chambers destitute. I'm sure the state will say something about how this incident shows how dangerous Mr. Chambers is. I obviously disagree with that. I think all the letters in support of him, all the people who continue to stand by him, point to the fact that any arguments that the state makes in that regard simply are not true, and that there are some quite significant appeal issues in this case. It also is, again, because of Mr. Chambers' age, may be of little actual consequence to him. So we're asking the court to set an appeal bond of $50,000.
Your Honor, may I have your Honor?
All right. I'm inclined to set that over to another day, and we can do that very soon. It's already 4 o'clock.
Your Honor, and actually, that brings up another issue. We emailed to you today copies of our findings on the 3.5 and 3.6 hearing. Obviously, we don't expect to address those today since we just gave them to the defense.
Right.
So we would need to have a hearing, and that could happen shortly. The only issue is to ensure that Mr. Chambers is not transported off to DOC, so that we might require an order from the court holding it here until those things occur.
so I'll sign an order then, ordering Department of Corrections not to transport him until I've held the hearing on the appeal bond and the findings on the 3536 motion. So,
And there's also actually, although I don't think the rules actually require it, but there was this motion to dismiss, we'd like to do a written order on that as well.
okay, right. All right, so. Okay. Yeah, go ahead, Ms. Day.
I just, in terms of the no contact, I have written on here, and I just to be sure it's all right with the board, that no contact, maximum term, which is life in this case, with Brenda Good, Jonathan Voss.
Hold on.
Victims.
I'm having trouble hearing you. Maximum term of life, you said?
Right, with Brenda Hood, Jonathan Voss, victim's daughter, what is her name? This is and also with Jody Davis.
All right, very good. Okay, we can set the hearing for Monday, the 16th at 8:30 if council are available.
That would be fine with us, except that, well, that would be fine, we have the other order. The only problem with that is that the other motion to dismiss order, I haven't done it yet, so that the defense might not have time to comment on it.
Okay, so what's your suggestion?
That would be fine, I just needed to let Mr. Goldsmith know.
I don't know whether I would have a chance to meaningfully look at it. Certainly on the appeal bond issue, I think that's fine. On the 3536, I'm not sure, because I'm actually,
Okay,
Is
well, what's your suggestion?
I
I
would,
don't have my calendar right in front of me.
how about either the 17th or the 18th?
Okay, how about the 18th?
Okay.
What time? 9 o'clock?
But I'm actually in trial in front of Judge Long,
Mhm.
so I would just ask for one of those trial times.
Okay, so 8:30.
8:30.
Okay, that's fine with the court?
8:30 on the 18th,
Yes,
and two issues, the findings on all these,
correct,
and also the issue.
right. And I will have had time by then to review the findings carefully.
And
so
I'll
will counsel.
provide the motion to dismiss order as soon as I get it to you.
Okay, very good.
Are you imposing any additional conditions of community custody other than the ones that the Department of Corrections would be imposing upon you?
No.
Do you want us to come to the bar during the fingerprints here?
Yes, I think that would be easiest.
I should just note for the record that the defendant has affixed his fingerprints on the fingerprint page of the judgment and sentence. And I'm also handing to the defense a copy of the judgment and sentence that I've signed and asked them to review it and sign it.
The box around was checked that this is a manslaughter in the first degree is a serious violent offense. I actually don't think that's true. I don't have the SRA right in front of me, but I don't, the SRA will tell us whether it's a serious violent offense or a violent offense, but
Okay, do you have the statutory?
yeah, it's 9.94A.030, which is just a definitional section, and then it'll be under serious violence.
Okay, why don't you go ahead and I'll look that up.
Okay, thank you. That was just the last thing.
Okay, it is listed under subsection 41.
Oh, it is.
as serious violence.
Okay, then I'm in error.
Your Honor, I might as well do this up here when Mr. Chambers is up here. I have some other documents to hand him through you, Mr. Waltzman. This is his notice of his rights on appeal. I'd ask that you go through that with the defendant, so he understands his rights on appeal, and have him sign it. All right, I didn't remember. What is Mrs. Chambers' name? Sarah? That's right, gotcha. Your Honor, I'm also handing the defendant a copy of his notice of ineligibility to possess a firearm and his loss of his right to vote. Mr. Chambers, in handing you this, I'm going to ask that you sign this. I'm informing you at this time that you may not possess a firearm and you have lost your right to vote. Both of those rights are removed at this time and remain in effect until further restored by a court. And I'm also handing through the defense attorney information regarding how to pay the mandatory penalties, the costs, the victim penalty assessment, and the DNA fee. And I'd just like to indicate for the record that Mr. Chambers did sign the notice of ineligibility to possess a firearm. And finally, I have an order that I have drafted, that I asked the court to sign, ordering that the defendant not be transported to the Department of Corrections
Right.
until further order.
That makes perfect.